Good morning to all of you. This video is for the law taught students, particularly regarding the insurance. Please remember, you should have insurance at the time of purchase of a vehicle, maybe comprehensive, maybe third party. It is your choice. Normally, when you purchase a new vehicle, definitely you should take comprehensive insurance. But after 5 years, even the insurance company will advise you to go for the third party insurance. It's okay. Please remember, you cannot drive an uninsured vehicle on the public street, public place, right? But when you sell the vehicle, the second-hand vehicle, that means having purchased the vehicle and having run it for 5 years, you want to go for a new one. So you want to dispose this one, definitely. So at the time of March ending or year ending, normally people are having the fantasy of purchasing new vehicles and disposing the old vehicles. Whenever you dispose your vehicle, you should intimate the transfer of your name from the insurance to the insurance company under section 157 of the Motor Vehicles Act. Section 157 says transfer of insurance to be done, okay, after purchasing the second-hand vehicle, after disposing of purchasing, both points. So normally people tend to forget the same. Nowadays, luckily, since the computer system has come, after disposal of the vehicle, actually now you are going and putting your thumb and automatically the vehicle is getting registered in the name of the other person. But previously, we used to fill Form 29, 29A and 33 forms. We used to take our original C-book and original RC there. We used to move around the RTO office for a days together. Then only they will be considered to get the transfer. Nowadays, luckily, since the technology has come, it is being transferred and the RTO is being intimated. That point is okay. With that, people are forgetting. But even though the ownership is changed from A to B, but the insurance is in the name of A. So therefore, insurance company can avoid their liability, stating that since the vehicle is insured in the name of so-and-so, but now so-and-so is the owner, we are absolved. We may be absolved from paying the so-called indemnity. We need not pay the compensation. Definitely they can raise that point. So to avoid that, and as per the law, statutory provision 157, you have to intimate the insurance company about the transfer of the vehicle. I think you may have to pay some 200 rupees or so. Definitely it will be transferred in your name, and the original owner will be absolved of his responsibility. Suppose if any accident takes place, against whom you are going to file the case? Number 1, owner. Who is the owner? As per insurance, you are the owner. Number 2, driver. Number 3, insurance company. So if there is a difference in the ownership, definitely it will be advantageous. So that's why please remember, any lacuna will go in favor of the accused person, right? So therefore, you have to get the transfer of the insurance after you purchase the vehicle, after you dispose the vehicle, in both ways. So anyway, it is the responsibility of the person who purchased the vehicle to get the insurance transferred in his name also, right? So this was stated in the case of Pushpa alias Leela and others versus Shakuntala and others 2011, right? So please remember, here what happened is C-book. So here the court held that when the ownership of the vehicle was transferred prior to the accident, here they have done, yes, prior to the accident, the ownership was transferred from Pushpa to Shakuntala. But please remember, neither the transferor, that is Pushpa, nor transferee Shakuntala made any steps for change of the name in the C-book. No doubt, they have disposed of the vehicle, but it was not made entry in the C-book or the insurance also. Now, who is the owner? Pushpa alias Leela, she is the owner as per the C-book and as well also MVAct and also insurance company. Right. Here what happened is, actually while disposing the vehicle, this Pushpa has given undertaking to to the other woman, Shivleela or somebody, Shakuntala. So an undertaking was drafted in actually on a bond paper stating that from today onwards I am the owner of the vehicle. After if any accident or if any claims are there, I will bear them with my own money. Of course, this is a civil liability. Of course, you can file a civil case, but it doesn't hold good. Definitely, it will be useful as a civil case. So please remember, here some accident happened and the legal hits of Premchand. That means Premchand, he died in the accident on 7/5/1994. Right? So the truck actually belongs to A, then it is transferred to B, but they did not inform the insurance company, as a result of which, due to the non-transfer of the records, this vehicle is held in the name of the so-called appellant. Therefore, she has to pay. Luckily, since the insurance company is there, I don't know what the justice has said or what the judgment has come, but here the important point is, whenever you dispose a vehicle, you get the name transferred, the C-book transferred in the name of the other person. At the same time, you should get the insurance also transferred. So this is the important issue in this case. You may get a question on this topic also. So please read the judgment and write in your own fashion. Thank you very much.